The Lawyers Committee for Civil Rights Under Law, in collaboration with a coalition of 5 prominent civil rights organizations, is defending a private grant program aimed at reducing barriers to entry for underrepresented entrepreneurs who own full-time package delivery businesses in partnership with Amazon. The program, which offers a $10,000 stipend to eligible business owners, is currently awaiting approval. However, several plaintiffs, who are white business owners, claim that Amazon's diversity grant program is discriminatory. Sabrina Talukder, senior counsel with the Lawyers Committee for Civil Rights Under Law, joins us now. Did I get your last name right, Sabrina?
You did. It's Talukder. It's scarier than it looks, but you were perfect.
All right, Talukder. Well, thank you so much for being with us. This is something that is not new. There have been people who have brought claims for this particular program before. Talk to me a little bit about the argument that is being made in court against this particular program.
Thank you so much for having me. And yes, this isn't the first time a claim like this has been made, but the gist of it is that plaintiffs who are white business owners are alleging that Amazon's diversity grant program is discriminatory. And under this grant, Black, Latino, and Native American business owners who have been accepted into an extremely competitive, selective program called the Delivery Service Partner Program are potentially eligible for consideration for a $10,000 stipend. However, like many other cases that bring alleged reverse discrimination cases against private equity initiatives, the plaintiffs have not applied for the DSP program, which is a prerequisite for being considered to the grant itself. These plaintiffs are saying that they're being harmed by the Amazon's diversity grant program and that they have legal standing to sue under a historic civil rights statute, which was meant to actualize the promises of the 13th Amendment and to ensure Black economic freedom at the height of the Black codes after the Civil War.
Mm-hmm. And, when it went to court before, as you said, the applicants they had not applied. In this case, they haven't applied either, correct?
Correct. This is a trend that we're seeing.
Yeah. So would the outcome you expect to be the same?
We are very hopeful and cautiously optimistic that the Ninth Circuit Court of Appeals, which is where this case currently sits, will affirm the ruling of the Southern District of California. The Southern District of California actually dismissed the plaintiff's lawsuit for lack of legal standing, which is not having a real harm, and for failure to state a claim, which is that there's no viable legal argument. And the underlying reason is because the court said that the plaintiff's claims are just conjectural, hypothetical, and speculative, that because they are unwilling to apply for such a highly selective and competitive program that accepts only 3% of applicants, that these claims just completely lack real legal standing under Article 3.
Mm-hmm. What would be the defense legal strategy here in something like this anyway? Because you do have a group of plaintiffs that are saying, hey, we have precedent cases, the Supreme Court, we have information in terms of what cases across the country have been determining that we need to be treated equally. What is the defense in that regard?
Well, I think first that the Supreme Court ruled on a different matter in the case of SFFA, which only pertains to higher education. And the line of cases that we've recently seen are attacks against private equity initiatives in the economic world. And in that world, we have seen most cases being dismissed all across the country in federal courts of appeal based on legal standing, because most of these plaintiffs have not actually filed for the program or the application process that they are challenging. And so a lot of courts haven't even gotten to the merits of the claim because these cases are so weak that they fail basic legal procedure. And that's what I really want folks at home to remember, that these attacks are not about merit or fairness. They're fueled by fear of competition, fear of change, and fear of an equitable future, because the programs that they're attacking, that they are not applying for, don't take away opportunities. They just level the playing field to maximize the talent and potential of all Americans. This program, the DSP program, creates jobs. It creates an ethos of self-reliance and just makes such an impact in the community where the DSP folks are from. And to attack this really underscores that what this case is really about is our core shared value that the American dream belongs to every American, not just the economically elite or wealthy.
Can you give us an idea about what Amazon had in mind when they started this program, and how many people have received this $10,000 grant?
The numbers are right now not available, but the program was, as you said in the beginning, it's meant to reduce structural barriers to entry for Black, Latino, and Native American entrepreneurs. And that's because there have been so many longstanding historical structural barriers for these communities to be able to start small businesses on an equal footing with white business owners. For example, Native American business owners accounted for 0.0015% of all venture capital funds in the last year. Black American and Hispanic American business owners actually also equated for less than 1% of all venture capital funds. And we're seeing even more rejection from loan investment firms and more because of structural inequities. For example, Native business owners can't use trust land as collateral. And ITINs, which is a tax ID number, cannot be used for many financial loan institutions. So a lot of people from Black, Hispanic, and Native American communities just don't have access to the venture capital funding, to the investment, and all of the materials and networks that go into creating a small business. But the reality is that every discouraged Black, Latino, and Native business owner represents an engine of economic growth that could have brought jobs, wealth, and so much more to the community and the country.
We're going to go to our panelist, Dr. Parr. Do you have a question for Sabrina?
Thank you, Candace, and thank you, Counselor. Thank you, Mr. Talukder. As we know, you know better than we do, these white masters have been after 1981 for decades. How concerned are you and other civil rights lawyers that the incoming administration will, in addition to not only not defending Section 1981, flip on the other side? I'm sure you know better than we do. Again, the Comcast case in 2020, the 1981 case where they kind of heightened the barrier by saying that it's not enough to prove that you might have been discriminated against, but you have to prove but for your race, you wouldn't have been discriminated against. And if they can offer some alternative explanation for why the program unfolds as it is, you can defend yourself against a 1981 claim. And my other question really has to do with standing. You walked us through standing. They have been out here in the Wild West saying, they don't even have standing. They can't prove that they were harmed. How concerned are you that cases like this might be more successful in a hostile federal administration like the Trump administration?
Well, I think to your first question on the future of Section 1981, I think that we've seen in this line of cases against private equity that has race remedial programs, we've seen Section 1981 really turned on its head. And you know better than me that Congress explicitly designed this act to further the aims of the 13th Amendment by creating a remedy for discrimination that curtailed Black Americans' ability to enter contracts and fully participate in the nation's economy. And in this case of Alexander v. Amazon, the plaintiffs have weaponized Section 1981 to eliminate a program that is meant to level the playing field for Black, Hispanic, and Native American business owners. And we've seen kind of a hodgepodge of cases about this. And we've had one case, which is known as the Fearless Fund, where Section 1981 was discussed. But the reality is, to go to your second question, is that a lot of these cases have been dismissed on standing grounds, which is just whether or not you have suffered a real legal injury that allows you to bring a case into an Article 3 court. And to the question of whether or not I'm worried about it, of course, in such a judiciary system that is, stacked with certain kinds of judges, we're of course worried about how any case will go. However, we have also seen cases like Alliance for Hippocratic Medicine versus the FDA decided at the Supreme Court based on standing grounds. And we are cautiously thinking about these issues just like you are. And we are hopeful that at least in Alexander v. Amazon, that the Ninth Circuit Court of Appeals will affirm the lower court's decision and dismiss the plaintiff's lawsuit for lack of standing, as well as failure to state a claim. Because, like I said earlier, this is not just any random grant program. This is a competitive, multi-tiered, highly selective program, which is race neutral. It has race neutral requirements. And you have to be one of the top 3% of, less than 3% of all applicants that apply to this program get it. And, these programs don't take away opportunities. Nothing took away the plaintiff's opportunities to apply for this program because the Amazon Diverse Grant exists. All this program tries to do is ensure that every small business owner in America gets a fair shot at their American dream.
All right, Cameron, question for Sabrina.
Thank you, Counselor. For kind of educating us on this. I have a kind of a two-part question. One, if this is a case that is able to set some level of precedent, if it goes into the appeals court, is that something that given if there is a precedent set, or if this does go the wrong way, is that something that can be used to dismantle other grant programs? And then more specifically, we're live right now on Roland Martin Unfiltered. And while we're doing our best to inform and educate people, we're 2 years away from the next major federal election. We need to give people marching orders to not just let them know something is happening, but what can the power of the people actually be able to be directed to do to be able to fight back against this? Because it feels that if an competitive Amazon program that is race neutral is taken down, it would what stops it from smaller companies who don't have the deepest pockets, or organizations that also want to put competitive grant programs that could help minority communities fight some of these structural inequities. They may not even go put those grants up, or they may look to reclassify or take some of those grants down, and that could have sweeping effects on folks who need these funds, who need these kind of support. So I want to know how we can direct people, and if this case does go the wrong way, does it set a precedent that allows other grant programs to go?
All right, Cameron, you sound a little muffled there, but I think we got the most of the questions. Sabrina.
I think so. And I think both of those questions are actually connected, because what we've seen across the country is that these cases have been dismissed because they lack standing. And again, standing is someone hasn't suffered a legal harm, because plaintiffs are not applying for these programs and they're not harmed by a program that helps other people and levels the playing field. But the reality is that if the Ninth Circuit Court of Appeals reverses the district court's decision, it'll only exacerbate a chilling effect that already exists. Across the country, we've seen private remedial efforts go through these really terrible chilling effects where folks are really scared to have DEI programs. And these programs close the very real economic gaps that the historical legacies of slavery, segregation, and racism have created in the United States. However, what we try to tell people at nonprofits or other small businesses is that legally you have the right to exist, and legally you have the right to have certain kinds of programs under many kinds of defenses. And it really depends on the organization and what they want to do and how they want to fight. But DEI and programs that are about diversity and accessibility are not outlawed in the United States. Again, the case SFFA really pertained to affirmative actions in higher education settings only. So right now, these programs are allowed, but this onslaught of litigation has just really had terrible chilling effects that affects the private sector as well as the nonprofit community as well.
All right, Robert, last question before we go to the break.
Absolutely, and I thank you so much for sharing this information. I've worked on amicus briefs in both 1981, 1984, voting rights cases, etc., and I've seen the legal playing field change over the course of the last decade or so, as conservative groups are really invested in attacking much of what we call the civil rights movement through the court system. If you look at Stephen Miller's organization, if you look at many of the other groups that are fighting tooth and nail to reverse every bit of progress that we've made, I wanted to take things big picture and talk about what happens if we lose some of these protections on the federal level. What we talk about in kind of lawyer terms often, we can talk about it from just the average person's perspective. What happens if we lose the protections that have been accorded to us under many of these legal frameworks that are currently under attack?
Well, I think in this instance, it's helpful to talk about it from an economic perspective, because this case deals with race remedial efforts in the private equity context. And what I really want folks at home to know is that rolling back diversity initiatives harms the country as a whole. If you care about job creation and you care about strengthening the US economy, you care about DEIA initiatives. And that's because entrepreneurs of color are more likely than white employers to hire from within their communities. And the reality is that every discouraged Black, Latino, and Native American business owner represents an engine of economic growth that could bring jobs, wealth, and an ethos of self-determination to their community and country. For example, you can just look at the DSP program and former winners that we've highlighted in our amicus brief. For example, we highlighted a Black woman who has a delivery service program in Maple Grove, Minnesota. She currently employs 100 people who are mostly people of color and has a starting wage of $20.25. And these are the kinds of localized programs that promote growth that will be cut for everyday Americans. And that affects all of us, because curtailing race remedial programs curtails the strength of the US economy overall. And I have two very boring statistics to share, but I think that they're pretty important. Okay. For example, the McKinsey and Company reported that if existing Black-owned businesses reach the same average revenue of white industry counterparts, we would get a 1% increase in GDP growth. That means an additional $200 billion in recurring direct revenues. And similarly, the Stanford Graduate School of Business found that if Hispanic-owned businesses could generate they can generate $1.4 trillion in additional revenue today if they were equitably funded. So the loss of civil rights protections, the weaponization of historic statutes like Section 1981, of course, impacts disproportionately communities of color, but DEI affects all of us. And that's why the core of this case is about a shared American value, that the American dream belongs to everyone. And small business owners especially deserve to be included in the American dream. And so if, as you were saying, the litigation landscape has changed so dramatically in the past few years, that if we care about strengthening the economy, if we care about presenting a strong economic front to the world, then keeping diversity initiatives is essential for all of us.
Well, listen, Amazon had this program for a reason. They certainly saw a need. Counselor Sabrina, I want to thank you so much for being with us and breaking down this information.
Hi, I'm Isaac Hayes III, founder and CEO of Fanbase. Fanbase is a free to download, free to use, next generation social media platform that allows anyone to have followers and subscribers on the same page. Fanbase was built through investment dollars from equity crowdfunding from the Jobs Act. People just like you helped build Fanbase, and we're looking for more people to help build Fanbase. We are currently raising $17 million in a Regulation A crowdfund on Start Engine. We've already crossed $2.1 million, but we're looking to raise more capital from people just like you that deserve the opportunity to invest in early stage startups without having to be accredited investors. So right now, I'd like you to go to startengine.com/fanbase and invest. The minimum to invest is $399. That gets you 60 shares of stock in Fanbase right now, today. And then use Fanbase to connect with friends, grow your audience, and be you without limits.